Good afternoon. Attorney Protective would like to welcome you to today's webinar, Seal the Deal, Effective Settlement Agreements to Resolve Your Case. Please reference your materials for information about today's speakers, Justice John Browning, Dean Darby Dickerson, Bria Riley, and Puneet Sandhu. With that, I would like to introduce you to our moderator and speaker, Dean Dickerson.
Thank you, Kate, and welcome to our panel and to all of our attendees. When I was a litigator, I felt settlement agreements were almost always rushed. But now that I'm in the client seat and have worked on many more settlement agreements, both connected to litigation and to help avoid future litigation, I know just how important it is to take sufficient time, think through the myriad important issues, ensure that the attorneys conduct the appropriate legal research, including about tax implications, and then leave some time to marinate and think through the what. So today, we only have an hour with you, but we're going to cover a variety of topics to spur on your thinking. So let's start with Bria. Bria, we know that careful drafting is important, particularly to avoid ambiguities and other confusion. Bria, are you with us?
Yes, I'm sorry, you went out there for a second, but I think I heard the question.
Yes, if you could talk to us about drafting with precision and avoiding ambiguities.
Absolutely. So I think it's important to first start by saying you need to know your client and know what's important to them when drafting, especially in consideration of the current facts of your case and what got you to the negotiating table with respect to settlement, right? So I think it's important to be a zealous advocate for your client when drafting while still ensuring that you don't get off on the wrong foot with the opposing party, which could make the negotiating unravel when it comes to settlement agreements, and I've seen that happen before. So where you can be amenable with drafting language that will go into the settlement agreement, I think that's really important with respect to being precise, avoiding ambiguity, and making sure that you're showing good faith to the other side that you do want to get this agreement signed and drafted and good to go. I think also with respect to avoiding ambiguity and drafting with precision is a lot of the templates that people start with have a lot of boilerplate language in them from a settlement perspective, and they speak a lot of legalese. And in doing so, it's not always in the best interest of your client's position. So I think it's important to be specific about your client's needs, what's included in the agreement, and specifically call that out in a way that isn't legalese, in a way that isn't vague or misleading or ambiguous. And then I think some important, drafting clauses to include in the settlement agreement to be as precise as you can. And forgive me, I'm coming from a insurance defense background from when I was a litigator, so I'm going to speak from that lens, but making sure that, if you're on the defense side, that you're not admitting to any liabilities or any facts that haven't been proven yet, making sure that the release language is tight and that it's specific to, the parties' obligations to each other and what claims they are releasing, both the current claims and any future claims that could arise, which is really important. And then, making sure, again, that other clauses like waiver and relinquishment of rights, fees and costs, payment terms, anything related to confidentiality is important, so that way the parties can't disparage one another or leave the table talking about what happened during settlement negotiations or in that agreement. I think those are all really important things to include in your draft of your settlement agreement to make sure that you're being precise and unambiguous, and to make sure that, you're walking away from the table with a good agreement that's going to protect your client and their position. So I'd start with those as my initial thoughts on how to avoid ambiguities in the settlement agreement process.
Thank you, Bria. John Browning, we have a question from the audience, and I'm hoping you might be able to share some wisdom on this. And the question is, shall versus will? Do you have some wisdom to share on that point?
Yeah, I would make sure that the settlement agreement is precise in its language. And so look at what the intent of the parties is. Is the intent to use something that is mandatory language? And there, the word shall is the preferred term over will. versus permissive language, which would be an example like may. So you want to make sure that the language, as Bria mentioned, is tight and precise. And I use the word shall or must is another perfectly acceptable example of mandatory language versus permissive language.
Thank you, John. And to the audience member who asked that question, I would indicate that Joe Kimball, who is one of our Scribes board colleagues, has done a good bit of writing on that topic, and we would refer you to some of his work. The other thing that you always need to think through in a settlement agreement are the payment terms and the tax consequences. And I actually like to get very visual with this and draw the diagrams, make checklists, and then with the timeline actually draw the timeline out. But you need to think about all those details. How are you making the payment? And if it's something like a wire that you might not do all the time, what else do you get all of that in advance? Call the accounting department, interact with the other side, make sure you know that information so that when the payment is due, you're not scrambling around with it. Are you getting the money to one person? If it's a physical delivery, is it UPS? Is someone signing for it? What currency is being used if your parties are in different countries? A big one that I really started to learn a lot about when I got involved with employment law is who are the payees and how many checks are you going to cut? That's important to know. Make sure you have the names right. Do you need to put the money in an escrow for some period of time so that conditions are satisfied? There are a whole lot of tax consequences, and that was something as a litigator, I didn't have expertise. So I learned very quickly to make sure that one of my tax colleagues was on call and could also help review the documents to make sure that we were asking for the correct tax documents to be signed, that we understood the tax consequences of the types of payments we're making, whether it was for an injury or maybe for child support. If it were my client getting paid, maybe I wanted to try to negotiate a tax gross up so that if it was taxable money, so that I would get for that person the amount of money we thought that they should have. So always have the tax consequences first and foremost in your mind. Puneet, I'm going to stop there and bring you in. I think you have an example to share regarding tax consequences.
Yes, thanks, Darby. This has scuttled more than one deal in my experience where the parties, before either sitting down for mediation or after going through a long drawn-out negotiation over a period of time, leave the tax language to the very end. And I had one example where we got agreement on all of the terms and the money, which is usually the hardest part, but opposing counsel wanted the settlement payment designated in the agreement as for personal physical injuries, so that they would have an argument that it wasn't taxable to their client. But this was an employment case, and there was no allegation in the complaint or any evidence developed in discovery in the case that there had been a physical consequence or physical injury. And the discussion of this went on for weeks. The insurance company got involved and said, that sounds like something that can get you audited. And in the end, we couldn't quite reach the deal there and had to come back to the negotiating table quite some time later. But I just think that's an example of why it's important to consult with outside tax counsel, or if you have a tax attorney colleague, while you're thinking about, on the front end, while you're thinking about tax terms. Don't become an amateur tax lawyer. Get the consultation that you need, but don't forget that not being able to agree on the characterization of settlement payments could scuttle your deal entirely.
Thanks, Puneet. And that brings us to a sample that we put in the materials, because I too have been involved in a case where someone on the other side indicates that they probably are going to characterize it a certain way to government entities, and we've written into that, hey, that's going to be your responsibility and that's on you. So we've given you a sample of some language to use there. And another thing to think about is, are there any liens, particularly attorney's liens, outstanding? You want to make sure if you're turning over money to someone, you have a global settlement if that's what you think you get. I had a case where, again, as we were drafting, we recalled that the person had started with one attorney very, very early in the matter and then had switched, and we just weren't sure if maybe that attorney was owed some money as well. So we've given you some a clause there to use as well. So with that, let's go ahead and turn to our release. John, the release is one of the most important parts of a settlement agreement. What wisdoms can you share with us on this topic?
Well, first of all, I agree with you, Dean Dickerson. The release really is the heart and soul. A well thought out, carefully crafted release is crucial to providing the outcome and the protections that you and your client are going to want. So what do we need to put in this in our careful crafting of the release? Well, first, understand what can and cannot be released. Certainly you want to make sure that you're not over-promising and under-delivering. You may have, for example, different jurisdictions have different rules about what can and cannot be released. For example, in cases involving minors, a parent is often not deemed capable of releasing the claims for a minor. And so some other representative of a minor, such as an attorney ad litem or some other representative, would have to do that. You also have to clearly articulate the scope of what is being released. Is this a full and final settlement of any and all claims, past and future, known and unknown? Does it have that broad language, or is this something that you need to narrowly tailor? You also need to identify all persons and entities that are being released. Identifying the key players is crucial because in many states, a party that is not identified or sufficiently identified or identified with enough particularity is not considered to be released. So we have to be very specific as to the parties that are in fact being released. And there I would also add that careful attorneys, and I'm speaking from the standpoint of being a litigator for 34 years and later an appellate justice who reviewed incidents involving interpretation of settlement agreements. You also have to pay close attention and care to who isn't being named. For example, if you have, as a defense attorney, an entity that's being released, does that entity owe any type of indemnity obligation to a party that perhaps is not involved in the settlement and may need to be added to the list of those being released, so as to avoid future litigation where a party that's later sued says, wait a second, you were supposed to protect my interests, you didn't, and now I'm facing a lawsuit. You also have to be specific in terms of the dispute that's being resolved. Summarize the essential points of the dispute that led to the need for the release in the first place in a straightforward manner with clear language. The more specific and detailed, the better the protection will be. And if there's obviously consideration that is supporting the release or property that's involved, again, be as specific as possible. Give a full description. And if there's property involved, give the legal description from the deed. If you're referring to sums of money, spell it out in words rather than expressing numbers. And then make sure that the settlement, that the release is reflecting the correct terms of payment. Is the payment being paid in a lump sum? Is it being paid in installment payments? You need to be precise in that. You also need to be specific as to the time period that's being covered in the release. Specifying the time period that the release covers is crucial for defining exposure to potential claims. Terms like 1 year from the date of or shall terminate on are far more preferable to an obligation that refers to a reasonable time frame. I mean, what does a reasonable time frame mean? It's ambiguous. You also, I think Bria mentioned before, the desirability of adding a confidentiality or non-disclosure provision to a release. And that is significant. You need to also keep in mind the many different dimensions that confidentiality and non-disclosure can have. For example, a case in 2014 in Florida, Gulliver Academy versus Snee, involved it was an employee discrimination case. The private headmaster or the headmaster at a private academy had settled an age discrimination case, received a settlement, signed off on a release that had a confidentiality and non-disclosure provision. Said you cannot discuss with anyone the existence of or terms of the settlement agreement. Well, the defense attorneys found out later through reviewing a Facebook post that had reached over 1,000 different Facebook users that the teenage daughter of the headmaster had made a post referring to the specific amount received and said that her daddy had settled his lawsuit with Gulliver Academy, and as a result, Gulliver Academy could go suck it. That fairly blunt term gave the defense attorneys reason to believe that the confidentiality had been breached. And so they sued for return of the funds, and the appellate court agreed that confidentiality means confidentiality including on social media. And that brings up another important part, Jenny release, and that is spelling out the consequences to either party if the agreement is breached. Consequences may vary. There may be payments, there may be monetary damages, repair, replacement, but adding those consequences eliminates future disagreements that the lawyers may need to address. So you have to address future unknown, unanticipated potential claims, and of course, identifying any conditions to the payment, to the release, such as the payment itself, such as necessary releases, such as releases of liens. And here, as a longtime defense practitioner, defense attorneys need to be aware that they need to address, if they're aware of a lien, like a Medicare or other federal government lien, that there may be secondary payer issues. You can't simply take opposing counsel's word for it that they will satisfy the lien or that the lien will be satisfied. You need to actually address this in your release, and you need to ideally get verification that the lien has been satisfied. So these are some of the many elements, but I would also include in the release, what is the governing law? Have a choice of law provision in case the release needs to be interpreted somewhere down the line. And you also need to address, the consequences of that breach. Many jurisdictions require that if you're going to seek attorney's fees for a breach of a release and settlement agreement, that you have to have that clearly spelled out in the agreement itself. Now, Texas has a statute, Section 38.001 of our Civil Practice and Remedies Code, says that attorney's fees can be recovered regardless of whether the agreement has an attorney's fees provision, but it's always the better practice to include that in your agreement anyway. And with that, I'll kick it back to you.
Thanks, John. One thing you mentioned was the numbers, and I touched on this very briefly earlier on, but didn't get into it. When I draft an agreement, I prefer to use numerals only. I feel like if you use numerals and words, there's a greater chance of creating a conflict or mistake. What's your view on that issue?
Well, I think regardless of whether the practitioner chooses to use spelled out words or numerals, they should be consistent in the document. So I have always preferred to spell out the words, so I will, have those in there. I may include a parenthetical that includes the numerals, but my primary descriptor is always spelling it out in words. But I try to be consistent throughout the document in that, and I think that's a good rule of thumb to avoid any kind of confusion.
Thanks, John. Puneet, I believe that you have a complication to share about the release topic.
Yeah, I mean, this is something that comes up when you use the boilerplate language you've used 100 times in old agreements, which is who is being released and have you defined who's being released? John touched on this, but this certainly becomes an issue. There's a tendency to say name of company and all current or future parents, subsidiaries, affiliates, current and former employees of the same, and on and on. You really need to consult with your client if you're representing, a corporate client, to make sure they lay out for you all of the entities that should be covered, so that you craft language that covers all of those subsidiaries, affiliates. Maybe there's members. You just don't know, especially if you don't do the corporate work for a client. You may not fully understand their corporate structure. And so that's something really that you need to review and make sure is defined appropriately each time you craft that release for each client. And remember that it might change over time. Corporate structures can change and names of entities change, and you need to be clear on who is supposed to be covered. Otherwise, you'll have that problem that John described, which is some entity that should have been included in the release wasn't, and that leads to later litigation.
Thank you. While we're with you, Puneet, let's move on and talk about researching the relevant law. I think sometimes lawyers look for a form or a template, and they're just grabbing clauses. There can be problems with doing that, right?
Yeah, I think that's sort of the biggest problem I see in drafting settlement agreements. Lawyers who do a lot of similar settle agreements can kind of be lulled into a plug-and-play approach. You pull the last similar agreement off your system, cut and paste the parties' names into the document, change the settlement numbers, and you think you're good to go. Or new lawyers might be tempted to do something similar. You pull an agreement from your firm's files, update the names and numbers, and move from there. I notice in particular a lot of newer lawyers assume that the boilerplate terms are both necessary and up to date without actually understanding why those terms are in there. And this approach to settlement drafting is dangerous. The law changes constantly, especially in certain states like New York and California, but it's true in jurisdictions across the country. So relying on an agreement from a previous case without reviewing all of the terms is tempting, but you really should resist that. You can certainly start with a template agreement that your firm has used in the past. You might even look online for samples, but you just have to be careful when you do so because the law is changing. So with each settlement, you should consider it your obligation to research all of the terms to make sure they're up to date. One example is confidentiality and non-disclosure clauses. Following the Me Too movement, several states have drastically limited the scope of confidentiality and non-disclosure agreements so that when an individual settles a sexual harassment, sexual assault, or even a discrimination case, they can't be prevented from disclosing factual information about the alleged conduct. And there's legislation in various states to add this. In California, it was already passed. We have Code of Civil Procedure 1001, which provides a limitation on non-disclosures so that they have to be, somebody releasing a harassment or discrimination claim has to be allowed to disclose factual information about their allegations. Because this keeps changing, researching the scope of what's permitted in your jurisdiction every time you enter an agreement is really necessary. The California law I just described, for example, has been tweaked twice just in the last 4 years to increase its coverage. You should also research the law in your jurisdiction about the enforceability of a confidentiality or non-disclosure term, because it may depend on whether the language is appropriately limited in scope and duration, whether the protected information actually is confidential. You may be asking somebody to keep confidential information that's already been disclosed or is public knowledge, and that wouldn't be enforceable. And whether the protected information arguably requires a party not to disclose illegal activity. All of these things could lead a court to either void the provision or even void your entire agreement, depending on the laws of your jurisdiction. Non-compete provisions are another example. These are absolutely prohibited in California in employment with very limited exceptions, such as the sale of a business. In other jurisdictions, they are permitted, but often the case law establishes that they must be narrowly defined in scope, duration, or geographically. Then you also have to think about, if the parties are in different states, which state's law would apply? Would your choice of law provision be effective? And what would happen if the other party challenged the validity under the laws of the state in which they are located? So also, depending on what industry is involved, you might need to think through or consult with other counsel if there could be antitrust consequences to the type of non-compete term that you're trying to impose in your agreement. Non-disparagement issues are similar to the confidentiality and NDA clause that we just discussed. Some states even have case law that says non-disparagement is basically not enforceable, or the case law makes it extremely difficult to prove. You should research the law in your jurisdiction so that you can effectively advise your client whether it's worth it in your jurisdiction to push hard for a non-disparagement clause, or if that's something that you could give up as part of the negotiating process. Liquidated damages are another issue that varies from jurisdiction to jurisdiction, but you don't want your clause or your whole agreement to be voided because a court finds that your liquidated damages are actually an unenforceable penalty. So you need to know in your jurisdiction what percentage of the total settlement amount have courts found to be enforceable as liquidated damages, and what language can you include in your agreement to explain why the liquidated damages amount is not a penalty. And for the reasons John stated, you should really look at the attorney's fees rules in your jurisdiction. Can you write language that makes it clear that the opposing party is not considered a prevailing party under a contractual term or by law in your jurisdiction? Is there a way to draft around that so that the total amount the parties are agreeing on to settle the case is the actual total amount that will be paid? I find that there's good resources online to point you in the right direction when you're researching the key terms. One thing you might look at is the EEOC website, or your state might have an equivalent anti-discrimination agency or civil rights agency. They sometimes have published settlement agreements on their website, or they may offer informal guidance about key terms like confidentiality, non-disparagement, and non-disclosure. That provides a good starting point as you research and draft. Westlaw also has a tool called Practical Law that has sample agreements for various jurisdictions, and it doesn't hurt to use their clauses as a starting point. They usually list when they most recently updated their sample clauses, so you can also use that to see if it's fully up to date.
Thank you, Nate. Does anyone else on the panel want to jump in with a comment on this topic?
I'd like to, Darby. A couple of examples that are referenced there that are specific to certain areas of law, such as employment law, point out the necessity of practitioners looking at the governing statutes and the governing law as they're making their settlement agreements. So, for example, the reference there to researching relevant law, determining if the client is 40 years of age or older, is certainly very relevant in employment. Resolution of employment lawsuits like ADA violations, where there's a statutory provision that requires that the settling party receive a certain number of days to consult with an attorney before there is any kind of effective agreement to the release. And then there's another provision that's referenced on our slide regarding quote-unquote magic language required by a particular statute. And I've seen this in Texas, where if you don't have the right language referring to the finality of a settlement agreement, if you don't specifically indicate that this is disposing of any and all claims, that if you're submitting an accompanying judgment, that you purport to be a full and final judgment, and that all claims are disposed of, it may be lacking what Texas courts have referred to as this Mother Hubbard provision, this idea that it is all taken care of within that document. Short of that, it may be considered something that is not as final, and certainly that's not something that any lawyer wants to hear, that an agreement that they thought finally and fully disposed of all the claims that were referenced isn't quite as final as they might have thought. So just a couple of comments on that.
Thanks, John. Let's stick with you. And given your experience as a litigator and as an appellate justice, can you share the importance of understanding and designating material terms in the settlement agreement?
Certainly. First of all, what do we define as material terms? It's anything that's essential to the bargain, the agreement that was reached. For example, the settlement amount itself. If that is missing somehow from the agreement, you're missing a key material term. And there can be no mutual consent where you have an agreement that refers to the release being drafted later. That's what a number of courts have ruled. So you need to be careful to include these material terms, things like the settlement amount itself, the parties that are involved, if there's a time frame within which payment or satisfaction needs to be made, who is going to be covered. If a court finds that the material terms of a contract are overly vague or not well enough defined to provide a basis for this mutual consent, it's not going to enforce the agreement. What constitutes a material term is going to vary from case to case. And we give an example from a California case, Weddington Productions versus Flick from 1998. There's also a very recent Texas Supreme Court case that illustrates the danger of not being defined enough in terms of material terms. There was a case earlier this year involving two entities in an oil and gas contractual dispute, and it was Finley Resources versus Headington Royalty. And this involved, and it's very convoluted, but my simplified example is that Headington was trying to get the benefit of a settlement agreement that had been reached involving Finley when Finley turned around and sued them for a tiny sum of money by Texas standards, $54 million. So you might say it got some folks' attention. But the case revolved around the meaning of a material term called predecessors. Now, we see all kinds of references when we're naming parties that are going to be released. We say any and all affiliates of a specific company, predecessor entities, successor entities, and so forth. Well, this was a classic case in which, after being sued, they wanted the benefit of the reference to predecessors. And the term predecessor actually has kind of a term of art meaning in the oil and gas field. And they meaning Headington, wanted to state that this referred to the predecessor in title, which was the oil and gas term of art. Finley said, no, this really should have a much broader meaning, a much broader protection, that it applies to any and all predecessor entities. And the court had to look at, just what is the plain, ordinary meaning of it, but then also look at this in conjunction with the context of the case. Predecessors grammatically referred back in the release to the entities being released, whereas in terms of syntax, the use of predecessors may have connoted a prior connection to the entities themselves rather than the land, which is what the term predecessor and title referred to. And the court concluded that even when an agreement is unambiguous, the context that may inform the meaning of the language includes objectively determinable facts and circumstances that provide some context to the transaction. Now, Finley was not named in the agreement. They were a predecessor in title, and they wanted the benefit of the release. And the court said, no, that's not going to happen. And again, it just illustrates the necessity of having material terms that are provided. You have to consider the format within which the parties are communicating. This is another key element, and it's illustrated by a number of cases, including some recent cases from New York. Parties that are negotiating and reaching a settlement agreement electronically, so for example, via an email chain, have to keep in mind that emails can indicate and support mutual assent that can constitute a valid settlement agreement. There was a case last year from New York, DT Net Lease, REIT versus Coughlin. And there, all of the settlement correspondence and the agreement itself took place via email. Well, when one side later tried to renege, the court held that the chain of emails indicating mutual assent and containing all the material terms necessary did constitute an enforceable agreement. And again, part of the examination in any case is going to be whether or not the emails contain these material terms, things like the settlement amounts, the identity of the parties, the format of payment. Will it be a wire payment? Will it be a check payment? Will there be some land transfer? Whatever it may happen to be, what time period is specified? All of these things are viewed as material terms. And if the email chain contains all the material terms, then yes, you do have a settlement. And there's another New York case, Philadelphia Insurance versus Kendall, that supports this as well, again, involving email communications. This, and we've offered you in this slide an example of a clause to use involving breach of the agreement where there's an acknowledgement by the party that the preceding paragraphs constitute material terms. So you have actual statements contained in the document that refer back to what is considered material.
Thank you, John. Before we move to boilerplate, I want to take two questions first, moving back a slide, Puneet, one audience member said, what is the significance of the block that says party is 40 plus years old? Could you tell us about that employment perspective?
Sure. There is a provision of the Older Workers Benefits Protection Act, the OWBPA, which is an amendment to the Federal Age Discrimination in Employment Act, the ADEA, which puts in provisions for settlements where a worker is 40 years or older. So in terms of settlement agreements, as opposed to a severance offering, which is a little bit different, in settlement agreements, the general practice for most employers is to put in provisions that demonstrate compliance with the OWBPA, that the employee had at least 21 days to review the agreement with counsel of their choosing, and that after signing, they had 7 days to revoke. There are other ways to draft a release under the OWBPA, but generally, most employment agreements would include a provision that the employee party has had at least 21 days to review and used as much of that time as they want, and a separate clause that says they have 7 days to revoke in writing after they sign the agreement. If the employee made an age discrimination claim under state or federal law, arguably you don't have to include the 21 days to review and 7 days to revoke, as long as you recite, and I would do it almost verbatim from the OWBPA language, that the employee had sufficient time to review, that they're entering into this agreement voluntarily, that they've already made an age discrimination claim, that they've consulted with counsel, and they're entering this agreement and waiving their rights knowingly. But you certainly do have to consider that anytime you're talking about an agreement with an individual who has been employed.
Thank you, Puneet. The other thing that I wanted to address is there was a question about often these settlement agreements are being drafted in mediation or during a judicial settlement agreement. What are some strategies to be able to take the time you need? Two suggestions. One is you have an idea of what might be in the agreement. Sometimes I go with a draft in advance where I've at least flagged the issues and thought through some of them, and then we try to work off my agreement. The other thing would be to come up with some of the key terms of the agreement, but to be very clear in your written, what I would call a term sheet, that this isn't a final or binding agreement. Assign someone the duty to draft the first draft of the agreement, set the timing to get a final agreement X number of days out, and keep the mediator involved. So those are just a couple of ways to be prepared and give yourself some time to research when you need to and to think through the issues. So Bria, every agreement, sure.
Oh, sorry, this is Puneet. Yeah, that was me. I was just going to say one thing I've done recently and mediators have requested is for, one party, usually the defendant, to provide a draft agreement to the other side a week prior to mediation. And so, the numbers would be blank, but if there are key terms the defendant's going to want in order to pay a settlement, it's helpful if you share that, copying the mediator.
Thank you for that idea as well. Thank you for that idea as well. Bria, let's move to you. Every agreement has some amount of boilerplate, which are standard terms that we typically incorporate. Can you share some tips about these clauses and also about sweating the small stuff?
Yes, absolutely. So as you all can see on the screen here, there's some standard boilerplate clauses that typically exist in these settlement agreements, but some that you may want to pay more close attention to or be more specific that I don't see mentioned here are clauses like, where both parties represented by counsel and making that evidently clear that both parties had an opportunity to consult counsel, have the agreement explained to them, specifically if you're dealing with a party that's a little less sophisticated, and making sure that they truly understand what they are signing and that there's no way for them to come back and, argue the voidance of this agreement because they were not prepared or didn't understand what they were signing or didn't understand what rights they were relinquishing, which is really important, specifically if you have, a less sophisticated party going up against, say, a corporation, for instance, because the benefit of the doubt is automatically given to the less sophisticated party. And then I usually like to incorporate like an investigation clause is what I call it. But basically what that means is that both parties have had a chance to sit with the facts. They both know which side of the facts are in their favor and which side are not, and they've used this to perform an investigation necessary to get to the point where they're at the negotiation table and they're ready to settle. So making sure that both parties have done their due diligence in getting to the negotiating table is going to be really important, and making sure that, that's customized in your settlement agreement. It's specifically called out as opposed to some of the boilerplate terms that exist. And Puneet mentioned earlier a really good example, especially since I'm in-house counsel now and I see some of these settlement agreements, about making sure you understand, specifically if you're representing a corporate client, their corporate structure and all the parties that need to be in the release and all the parties that, need to be identified in order to be properly protected. And if you don't understand their business or their corporate structure, being sure to ask about that and specify that within the agreement. And then in the example that John gave about the case involving the oil and gas industry and the issue line on whether, what the definition of predecessor was. Had someone took the time to maybe incorporate like a definition section in a settlement agreement, specifically if you're dealing with two very sophisticated clients in a very specialized industry who have their own interpretations and definitions of what certain terms mean, and they relied upon those to reach the settlement agreement, and the terms within that agreement, as opposed to just, what a layman's definition would be for that particular term, or what the Webster's dictionary definition would be for predecessors. In that situation, it would have been great had they been able to define that term so that way there was no room for ambiguity as to what a predecessor actually meant. And then for me being in-house counsel, working at a corporation, we have very strict payment terms and settlement agreements included, right? So being clear about when those payments are due, if they're on a payment schedule, what the deadlines look like, making sure that, you're getting that paid out within a certain fiscal year before the end of the fiscal year, before budgets close, specifically if it's coming out of a certain business unit's budget, and being really particular about when they have to pay that money if, the corporate client is the one paying a certain settlement amount. And then I'd also say being specific about the recitals and the parties' obligations, right? So if there are certain events that led up to the parties reaching settlement, and those events are extremely important, each party relied upon those in order to reach the settlement, put that in the recital section or the parties' obligations in the agreement, specifically if you're going to have a boilerplate clause about the entire agreement and everybody's understanding being incorporated within that agreement as to why the agreement was reached. So those are some of the ones that I think really pay close attention to and specify and make sure you're tight around the language that you use, as opposed to just sticking boilerplate terms in your agreement, specifically with respect to like the jurisdiction and the choice of law. Especially if you represent a big corporation, there's some states that are just more friendly to corporations than others. So it's important to keep that in mind if you're going to choose a choice of law provision, and that you're choosing one that would be favorable in a breach of contract case were this agreement to be litigated, right, to your client and to their interests. And then I would also say sweat the small stuff. It's very important. I always say the devil is in the details. So you want to make sure when you're going through settlement agreements and you're drafting them that you're checking things like the section numbers and cross-references, especially when you have multiple drafts flying back and forth between the parties, and making sure that each section aligns with what is being identified in the agreement and what's being referenced. Double checking the dates and the deadlines, like I mentioned earlier, specifically about the payment schedule if you work for a large corporation. Ensure that you haven't left any stray names from another agreement in the form. I've seen that happen. I've caught it right before the agreement went out the door. That's extremely important. Making sure that, their names and their designations are correct and consistent. And like we talked about previously about defining terms if necessary and making sure that those are consistently defined. And then correctly labeling all the appendices and exhibits to your settlement agreement is going to be really important, specifically if you're addressing that within certain terms or conditions or obligations within that agreement. And making sure that the person signing each component or the agreement itself possesses the sufficient authority. You never want to reach a settlement agreement and you think it's well and done, and then someone comes and says, well, that person actually didn't have the authority to sign that agreement on our behalf or to enter that or to agree to the terms and conditions of that agreement, and then it all gets unraveled. So really, really important things to pay attention to that is really hard to keep track of sometimes, like I said, when you have multiple drafts flying, or when you're just in a rush and you're doing a plug-and-play situation, and you shouldn't be, especially when it comes to things like settlement agreements, relinquishing certain rights, paying large sums of money, or whatever you're agreeing to within that agreement. It is extremely important to make sure you're paying attention to the details as well.
Thank you. Everywhere you look today, someone is talking about generative AI. John happens to be a nationally recognized expert on this topic, and I'm going to ask him to talk for a few minutes on it. I know Bria has some thoughts, and then we have one more topic after this that we're going to get in 7 minutes total. So, John, take it away.
Okay. Well, Darby, I think, the next slide really summarizes the key point. Use of generative AI, as long as you're using it wisely, is perfectly fine. It can be fine as for brainstorming purposes, but it should not be used as your primary resource for drafting. It's funny, earlier this year, Walter Kluwer's did their Future Ready Lawyer Report, a survey of thousands of lawyers. 73% of lawyers responding expect to integrate generative AI into their work within the next year. But if you look at the percentage of those who feel prepared for this change, it's far lesser. Now, the short thing about generative AI, things like ChatGPT and its current incarnation, co-counsel, Bard, there are so many different variations, I can't list them all, but they're used for multiple different purposes, and most of them involve things like, and blog entries for your law firm website or routine correspondence. It can be used in drafting of briefs, but I wouldn't make it more than the initial draft, your rough draft that still requires your independent professional judgment as a lawyer. But it can also be used and is being used in drafting contracts, including settlement agreements. And many large corporate entities have got their own proprietary generative AI products that do this. Companies like Coca-Cola, companies like JP Morgan Chase. However, where routine and often used terms and definitions, as was mentioned before, may be used routinely again and again, use of a generative AI tool that will be referring back to and speeding up the process by using these resources, these past releases and past agreements as templates is perfectly fine, but it should not be considered a substitute for the independent professional judgment of the lawyer. And of course, we all, as lawyers, have ethical duties, both our duty of confidentiality to our clients, and as well as our duty of technological competence to be aware of the limitations of generative AI. Now, all too often, we've seen the stories in the news, no need to go over those, of lawyers who have viewed generative AI as a substitute for their own work, lawyers who have used it to just generate briefs complete with legal research that comes up with cases that were made up, were what we call in artificial intelligence hallucinations. So we can't allow that to happen. And settlement terms, as Bria and Puneet have already indicated so well, need to be specific enough and need to have these key considerations, like the relevant case law and the industries involved, and the client that you were doing this for. So it's no substitute. It can help you craft a first draft, but generative AI tools like ChatGPT-4 are no substitute for the attorney's judgment. And with that, I'll turn it over for further comment.
Bria, I think you had some comments on this topic.
I did. I just wanted to drop in there. I agree with everything that John just said. And then also be careful what information you are putting in a generative AI platform, because that information is used as a repository to then go out there and be put into the universe, so that way other people can pull from it when they're entering their data in the platform as well. So if there are any confidential terms and conditions or facts related to your case that should not be revealed, be careful when prompting the AI tool, using that as a way to spit back out information to help you draft like a settlement agreement in that situation. And just be really careful about using that tool and using your own judgment and making sure that you're checking and fact checking and verifying the information that the AI tool spits out, because it's not all factual, it's not all correct. It's pulling from the universe and a multitude of different things. And it still has to be fact-checked because it's not as intuitive as, say, a human subconscious, So very important things to pay attention to as we begin to use this technology, which can be used for great things, and we've already seen that. We use it a lot in our own day-to-day world. It's just kind of starting to hit the legal tech industry, but please be sure to pay attention to those call-outs as well.
Puneet, bring us home with this last topic, reviewing the agreement with your client.
Yes. I mean, in my view, the number one most important thing you can do in the settlement process is to review the settlement agreement with your client. After all, your client is the one who will be bound by the agreement. They need to understand what legal commitments they're undertaking. And this is true if your client is a relatively unsophisticated individual in a personal injury case or an employment case, or if they're a sophisticated corporate client. With individuals, if you don't take the time to review key terms with them in advance of a mediation, you risk that the client's going to balk at signing after an exhausting long day where you finally agree on a number, but you can't agree on the terms. Preparing in advance with your client helps ensure that the individual understands the agreement and doesn't feel that you as the lawyer rushed or pushed them into settlement. And for sophisticated corporate clients, we've talked about this a little bit, but sometimes they want language to address specific disputes or challenges that have come up in the past that you would not have anticipated. So it's important to understand why they might want certain clauses that you wouldn't normally include, so that you can explain to opposing counsel in the course of settlement negotiations why you need that specific language. And finally, I would say keep good records of the review process with your client to demonstrate that you gave your client sufficient time to review and that you reviewed the settlement terms with them. Detailed notes are important, so are confirming emails. That way, if there's ever a question later, you've documented your efforts to ensure that the client was fully informed of what they were agreeing to.
Thank you, Puneet. Thank you, John and Bria as well. And I'll now turn it over to Kate.
Thanks, Darby. And that concludes today's event. On behalf of Attorney Protective, I would like to thank all of you for joining us for today's webinar. I would also like to thank our speakers, Justice John Browning, Dean Darby Dickerson, Bria Riley, and Puneet Sandhu. Thanks so much. Have a great day.